Assalamu alaikum, bismillah, and this is where my Arabic stops. I'm sorry, and I'm going to continue now in English. Well, I'm very honored to be with you and to expose you about the changes of governance caused by the emergence of the energy concern through social and environmental responsibility. The litigations and the arbitrations on energy will be significantly influenced by the new regulation adopted all over the world on energy and especially greenhouse gas and its influence on governance. While governance may have been born and developed through soft law and characterized by the comply or explain principle, today it is increasingly governed by hard laws, rules that are binding on companies. Social and environmental responsibility has become a significant contributor to corporate governance in the form of obligation to say and obligation to do. This transformation is so obvious that the French Market Authority, the AMF, in 2022 report is entirely devoted to this transformation. And one author observes that taking charge of SER issues is in fact part of the Director's general mission, which is to ensure in all circumstances that the company's interests are defended. France has been a pioneer in this major evolution of governance rule, which are now spreading throughout the European Union and beyond. Climate change, global warming, the growing scarcity of fossil fuels, minerals and water, and the desire for fair treatment are forcing major projects emerging in the Middle East and in the world to incorporate these new rules of governance. So we now are going to examine the obligation to say, to disclose, and implication for governance. Several reporting obligations have been progressively imposed on French companies and most European companies since 2010. The French company with more than 500 employees are required to draw up a balance sheet of their greenhouse gas emission accompanied by a summary of the measures envisaged to reduce these emissions. There is a directive called Non-Financial Reporting Directive, European directive. And the French listed companies that exceed certain thresholds in consequence of this directive are required to draw up an extra financial performance declaration, which contains a wide range of information on how they take into account the social and environmental consequences of their activities, such as the impact on climate change, etc. The European Commission has published non-binding guidelines in 2017 and 2019 on non-financial information containing indicators to be filled in by the company to report on its social and environmental impacts. There is a second directive called CSRD for Corporate Sustainability Reporting Directive. It is transposed in France by a law dated 6 December 2023. Non-financial reporting obligation for listed European company and large corporation meeting certain thresholds, and in the second phase, for listed small and middle enterprise once they meet certain thresholds. The Article 40 of this CSRD introduces an important novelty, that is that the reporting provisions will apply not only to European companies, but also above certain thresholds to foreign companies established on European soil. The Article 29 of this directive, CSRD, provides for the option by delegated acts of the European Commission on the proposal of EFRAG, IFRAG is European Financial Reporting Advisory Group. So it is not at all an elected group, and they will establish some standards known as the European Sustainability Reporting Standards. And this delegates decision by the European Commission augur well for a significant and rapid increase in CSR rules for the governance of European and foreign company operating. And now let's examine the obligation to do or not to do, and the implication for corporate governance. The introduction of ECR into the French company law. In France, as I told you, France is a pioneer in this matter. There is a PACT Act on May 22, 2019, that gives rise to two important articles in the Civil Code, the French Civil Code, that bring ECR obligation within the scope of a company's statutory missions. The first is the Article 1833 of the Civil Code, and it says that all companies must have a lawful object and be formed in the common interest of the partner. And this is very classical at this stage. But what the novelty is that the article continues and says that the company shall be managed in its corporate interests and taking into consideration the social and environmental challenges of its activity. So it is a very huge change. And there is a second article, which is 8035, that says that the bylaws of the company may specify a reason to be, raison d'être in French, consisting in the principles which the company adopts for the respects of which it intends to allocate resources in carrying out its activity. This development, which may some dream of seeing coming a revolution, accelerate the transformation of governments into a body of mandatory rules. All companies are now concerned by ECR obligations, large or small, listed or unlisted, civil or commercial, limited or unlimited liability. And we can say that a company failure to anticipate ECR issues relating to its business could result in its liability being incurred. To guard against this risk, companies are strongly advised to include their ECR concerns and the resources they have dedicated to meeting them in their corporate documents and customer communication. So there are also the climate resolutions, or say on climate. There has been an increase in the number of climate-related resolutions submitted to shareholders' meetings around the world, especially in the United States, a sign that this environmental issue is becoming a major concern in corporate strategy. In France, say on climate is defined as a shareholder vote on a resolution placed on the agenda of a general meeting at the initiative of the board of directors or one or more shareholders relating to that company's environmental strategy or policy, and in particular its climate impact. Several observations can be made. The first is that the climate resolution provoke a struggle for influence between the board of directors and shareholders, who try to impose their presentation at the company's general meeting of binding climate resolution leading to changes in the company's climate strategy. The second is that the board of directors assume their statutory role by personally drawing up the company's climate strategy and then informing shareholders in the form of climate resolutions submitted for their opinion. The refusal of boards of directors to admit climate resolution leading to a binding vote is provoking a debate in the marketplace, which the AMF is calling for to be resolved through legislative intervention. And in a report published In March 2023, the IMF Climate and Sustainable Finance Commission even recommends that the IMF should be able to take the place of the judge, and become the court of first instance to rule on the admissibility of a climate resolution submitted by a shareholder and refused by the board of directors. This development is highly significant in terms of the risk of climate norms overturning traditional corporate law rules, and in particular the risk of calling into question the role of the board of directors in defining corporate strategy. This development is no less indicative of the propensity of independent administrative authorities, in this case the Autorité des marchés financiers, to increase their powers even to the detriment of the judiciary. The debate in the marketplace may be somewhat perplexing. The essential mission of the boards of directors is to define and protect the company strategy within the framework of the elective mandate entrusted to them by the shareholder. The position of the board of directors appears to be in line with the company's corporate interest and respect for the separation of executive and legislative power. This separation thus has been confirmed by rulings of the Civil Division of the French Supreme Court, Cour de Cassation of France. The company's climate, legal risk, and ecological damages. The challenges to a company's climate responsibility. The ECR commitments imposed on companies give rise to a risk of their liability being called into question in the event of a breach of their ECR commitments, which can be easily detected by comparing the company's published commitments with its climate achievements. In a judgment dated 26 May 2021, the Court of The Hague, basing itself on Dutch tort law, ordered Royal Dutch Shell to comply with its plan to reduce greenhouse gas emissions and consequently to reduce its emissions by 45% by 2030, as it has undertaken to do. In France, the same threat hangs over companies, all the more as there is a law on the duty of vigilance of parent company dated March 27, 2013. This law of duty of vigilance justifies the commitment of climate actions. This law introduced a duty of vigilance for companies with more than 5,000 employees, which are obliged to draw up a vigilance plan containing the measures they undertake to identify risk, prevent serious infringements of human rights and fundamental freedoms, the health and the safety of individuals, and the environment resulting from the activities of the company and those of the companies it controls within the meaning of article of law, as well as the activities of subcontractors or suppliers. So this law was invoked positively by association before the French court against Total subsidiaries in connection with an oil development project in Uganda and Tanzania, partly located in a national park. And by a ruling of February 28, 2020, the claim was dismissed on the grounds of inadmissibility without prejudice to the merits of the case. On January 28, 2020, the French non-governmental organization and a number of French cities and local authorities, including the cities of Paris and the cities of New York, brought a suit against Total before the Tribunal Judiciaire of Nanterre, seeking the company's compliance with the law on the duty of vigilance. And the court has not yet given its verdict. The legal risk is confirmed by the fact that a large number of lawsuits are currently before the Paris Court of First Instance against major companies, as Casino and Suez, and also against the state organization, the French state organization, as demonstrated by a recent decision of Tribunal Administratif of Paris. That confirms the existence of a risk of condemnation of such a state organization for ecological damage, even though, in that particular case, France managed to escape the condemnation. In Europe, European Parliament adopted on 1st June 2023 another directive called CSDD, Corporate Sustainability Due Diligence, and the legal risk is absolutely confirmed. There is also to talk about the ecological damage. In France, the oil spill caused by the sinking of the oil tanker Erika, chartered by Total, gave rise to case law from the Court of Cassation that enshrined an autonomous ecological prejudice now governed by the law, the French law of August 8, 2016. This ecological loss has several singular characteristics. It constitutes a new category of prejudice in addition to the classically reparable prejudice. It can only be claimed by a limited number of persons depending on their status and interests. And it is compensated first and foremost in kind, and if this is not possible, by damages dedicated to the environment of the states. The law, French law, has also created a number of criminal offenses carrying prison sentences and heavy fines, such as the offense of ecocide, punishable by up to 10 years imprisonment and a fine of 4.5 billion euros. This underlines the risk run by the companies that underestimate the importance of ensuring sustainable governance compatible with the new ECR provision. In conclusion, one assists to the emergence of implementing of all over the world of new energy rules and regulation that will govern the economical activity of the planet for next year. The example of France and Europe is particularly demonstrative of this evolution that will conduct to introduce in all the governments and contractual relationship the need of the respect of ECR regulation. Therefore, one can predict increasing claims and disputes about interpretation of these ACR obligation rules and organization of use of energy that will constitute a large part of the future litigation and arbitration cases. Thank you.
Thank you to Dr. Philip. And now, if there is any question, the floor is you, the second table. Yes. Organizers, please present the mic.
Thank you, Dr. Philip. That's been very informative. My name is Ahmed Nasruddin. My question is regarding the three parameters of the sustainability, the environment, and the social and the governance. And you said that in France there is a specific legislation for companies that have more than 500 employees. In theory, if this company have like 490 employees, would this still be applicable or not? It wouldn't. But a company with 500 employees would be a major company. And now, after this legislation, they add to their cost the compliance with the sustainability requirements regarding the environment and the materials and the resources. They add as well, on the social side, the diversity and the training for their staff to comply also with such requirements of this new legislation. For example, like you said, Total or any oil company, they have in their cost a contingency for an oil spill. But now they have to increase their cost to take in their cost the new fines that they will face if they do not comply with this new legislation.
Certainly.
Yeah, so this built up of increasing cost,
Yeah.
how was it handled in France, someone who is pioneered in this, as in terms of, do they have, for example, exemption on their taxes or in their fees or charges or something like that, or how the model in France worked? Thank you.
The answer is not so easy, because you understand that the transformation is major, and it's something very new. What one can say that as a paradox, France is a pioneer. I say paradox because, as you know, France is a leader in the nuclear electricity, and the emission of green gas in France are very, very low because of that. But as a paradox, the legislation is very developed, and as I said, we have now in the civil code of French, in the French civil code, 2 new articles that obliges all the company, even though the company that are very small, that have not 500 employees, to comply with the SAR rule and to explain how they comply with it. So this is what I call a very important risk, because the judge is going to come and is going to interpret this regulation. What kind of obligation is that for the company? Is that an obligation of results, or is that an obligation of best efforts? One don't know. And if I was a company, I would be worried, and I would ask lawyers immediately to try to anticipate what is going to happen and to take the minimum of risk. The problem is that if you put a plan and if you explain what you do, you can be sued before the tribunal because what you said has not been done. If you don't say it, you will be sued also. So the solution is not obvious, you see? So what one can say is that very recently I talked about a decision of a Tribunal Administratif of Paris that released France from the accusation of non-respecting these SUR rules, because it was doing well, but it did not achieve this obligation. So one could say that the tribunal did consider that this obligation is an obligation of best effort for the moment. But who knows what is going to happen, because it comes from everywhere in the world, from the state, but especially from France and Europe. So.
Thank you, Mr. Philip. Another question here, Mrs. Doctor.
Thank you, Doctor. Family companies play a very important role in the economy of every country, and they have a very significant contribution. However, unfortunately, in many places, from the second generation or the third generation, the family companies are no longer there. And I think one of the good solutions for family companies is to adopt proper family corporate governance. And I believe that if you have a family constitution is one of the solutions in applying corporate governance. What do you think about this family constitution, and how it affects the promotion and existence and continuation of family companies? Thank you.
Well, thank you for your question. I think you're absolutely right that the family company are very diverse. You have small and you have very large, especially in Middle East. You know, so these companies have very different interests. But in any case, the governance is made to make that the different organs of the company work together. I mean, the General Assembly, the shareholders, the board of directors, the executive, and the legislative power. So the governance is composed of legal regulation, but also of contractual regulation. And this is where the company can work on for governments in making some rules, internal rules, to accommodate governance in the company. Of course, for the family, for the family businesses, the most important question is how to transmit the company to the family members. Yes, it is very difficult. But to rely what your question with my intervention, I think that even the family businesses now have to deal with the ECR rules, because it becomes some part of the government, and they have to think about that, and to think that the interest of the company has to be respected, just like you said, but not only. Not only. This is what is troubling, because now the company has to respect its interest, but also the interest of the environment. So it's troubling. It's troubling because you have to add some new regulation, new interests. See?
What about registration in the securities market?
Sorry?
Thank you, Dr.
The importance of registration.
Thank you, Dr. Abdel Qadir. You have one question only, Dr. Yeah.
My name is Abderrahim El-Kashif. I'm a judge at Cairo Court of Appeal. Thank you very much for this fruitful presentation. You mentioned that the source of governance in France encompass hard law and soft law.
Yeah.
The soft law like guidelines and code of conduct. To what extent companies in France comply with the soft law? And what type of sanction if doesn't comply? And this is still applicable in as to activities of the company outside France, like in Africa?
Well, yes, they have to apply soft law, because in my opinion, soft law is something that is not very correct, because soft law is the principle that says comply or explain. So if soft law, if you have the right not to comply, it's fine, it's soft. But more and more, this principle becomes a hard principle. So you have to explain why you don't comply. And in that sense, I talked about the AMF, Autorité des marchés financiers, French authority. It takes its role very seriously, and it imposes to the companies to comply. It gives them some guidelines to the companies, the listed companies, and they have to apply it. So more and more, the governance rules are becoming binding rules, more and more. And if you're talking about what happens for the companies that exist outside of France, they can have their responsibility engaged, just like I said, for Total, that was sued in France because of project in Tanzania, because it doesn't respect what say the complainant. It doesn't respect the ECR rules, you see? So this is very major problem for the company, how it is.
دكتور سحر هواري, you are ready ان انت تعملي, you are ready, دكتور سحر هواري, ready for question please, or yes, please the organizers, please send the mic to Dr. Sahar Hawari. You are most welcome in our conference, and your speech will be add value to all of us.
Thank you, Doctor. Dr. Sahar Hawari, I'm a university professor in media and ex-member in the FIFA, International Football Federation, and ex-parliament member in the Egyptian parliament. Of course, it was very fruitful, and we really benefited a lot from all the information that we listened to today, and especially in your session. I would like to ask that in the former speaker, Dr. Abd. Everyone was asking about in our situation in the Middle East and in our region, the Arab region mainly, how is it the soft law implemented, but versus the hard law. I think that soft law is an international understanding now, and it's implemented all over because now, even in our region, it's multinational companies. So in order to have or to upgrade our economic status, we have to. It has nothing to do with ethical obligation. We have to abide with the soft law because it's now, this is an international understanding all over, and we are having a lot of international finance going on, international dealings in our economy in order to upgrade our economic status. So I think now it's by law, it has to be implemented by status quo, like the situation in France and in Europe and all over. So I think that this is an obligation, and it has to be, there should be guidelines like a law, yani in the, well, it has to be implemented like as if it's a hard law. It's time to do this now. And I think that the Egyptian parliament, I just want to give a bit of information that now the Egyptian parliament these days, I mean this week for example, they are discussing some amendments in the law of the associations, because now we have to do everything for the international understanding, and we have to harmonize all. So now they are studying this, and also penalties and whatever. It's going to be implemented because some of the judges were discussing this issue, that it has to be a hard law so that they can deal with it. Because now in the court, our problem is we have the constitution. And our constitution has part to do with the French constitution, by the way, in history, back in history. But some details in implementation, it's not implemented as in France. So that's the problem, the conflict that the judges face. So we have things in our constitution which is not abiding or complying with the laws, articles in some of the laws. And that's where the conflict is. So we have to do some revision for at the end, our laws have to be revised so that we can comply with the hard laws. Because the soft laws now, some people understand, the multinational companies that we work with here, work together with international companies, because we have to abide with the international statutes. Other the business, we lose the business. Yeah. But the national entities still have to more understanding and more obligation by the hard laws. So I just wanted to say this part because I think it can clarify some points. I don't know if it did or not. Thank you.
I don't know if it is a real question. But
it's not a question. They said
it
we
was
need
an observation.
Yes.
But what I can just answer is that I came here to expose you what happens in Europe and in the States, but most particularly in Europe. And this become international standards, as you say. And these international standards shall apply in Middle East, in all the Middle East project also, if I think. And this is why the Middle East companies have to prepare themselves. And they have to prepare themselves before the legislative intervention by soft law, because the soft law is made for this. And the soft law in making the contracts, in making into the bylaws, you know, and preparing to be ready to explain how they respect human rights, environment, and all these new issues.
Doctor, in the last table, yes. Please, the organizers deliver the mic. يا جماعة السادة اللي قاعدين، لو حد عايز يسأل بالعربي واحنا نترجم بالانجلش مرحب بيكم. احنا بنتكلم عن الحوكمة بالقطاع الخاص والشركات العائلية، يعني ما فيهاش أي حاجة، اللي عايز يسأل بالعربي واحنا هنترجم السؤال.
Thank you, Professor, for your evasive description. My name is Dr. Basmal Sioufi. I'm an institutional consultant, institutional excellence consultant back in Saudi Arabia. First of all, governance as in terminology was discussed and thoroughly in many countries. And I remember I heard that terminology back in 2006 since it was raising and discussed in Saudi Arabia. My question to you, as I see the norm and just general discussion about governance and climate change, as far as I know, it concentrates on mitigation, then adaptation, then means of application to all the rules and regulations we do about governance. As much as we want it to be enforced by law, and done internationally, then done regionally, and then done on countries, as much as how far do we encourage the companies or the governments to abide or to really go into the race of excellence, as much as it is an inner soul of the company or the organization to align with the governance, align with being excellent in performance and also in profit-wise or even on a global scale. As much as we're dealing with enforcing the law of governance in order to become better, in order to be excellent in our performance. I just want you to highlight or to shed a light on your advice. How much is it really something we have to enforce by law, or is it something that could be nurtured or developed and taken care of inside the companies? So it is the concepts that should be really followed by all governments or companies. Thank you very much once again.
Well, I think that. Of course, the ideal situation would be that the companies do it by themselves and with the soft law. But it doesn't happen. It doesn't happen. So there is a need for regulation. There is a need for regulation by governments, by parliaments, to oblige companies to adopt this new regulation and the government, the governance regulation. This is what happens in Europe for many years. And you see a very large increase, development of binding obligation of governments that didn't exist 20 years ago. Now they are. And they are here for small and large company, both for listed, unlisted company. So I think the best is to go to parliament and governments. But in the other sense, if the parliament is not doing so quick enough, if the government is not doing quick enough, the company has to take into consideration its interests. Its interest is to develop its activities, to develop trust with the stakeholders, and in that sense, and with the shareholders. And in that sense, you cannot ignore what happens in Europe. You cannot ignore what happens in the States and everywhere. You have to go forward, and you have to prepare yourself for what is going to happen, because it's a tremendous change. So in that sense, I would say that the answer is to privilege both situations. The emerging of regulation and the comply or explain system through the adoption by the companies of internal rules in the bylaws, in the special regulations of the company, to prevent for actions and to put confidence into the company.
Thanks, Doctor. Okay.
My name is Samah Al-Agha. I am the program director of law program in Dar al-Hikmah University, Saudi Arabia. Actually, I just want to add something that the people in charge of achieving the governance should be creative. How to the stakeholder get or apply or implement the guidelines. And in this regards, I want to give an example about the Financial Action Task Force to combat money laundering the headquarters in Paris. And there is a list of guidelines how to combat or how to fight money laundering schemes. And annually, there is a report by country members to this headquarters. But the guidelines are distributed not only to the members, but to all other governments worldwide. And if they don't apply these guidelines, the Financial Action Task Force prepare a list. And this list is called NCC, not cooperative countries. So, and they distribute it to all other countries or government worldwide. And this is very, I think it's very efficient and effective weapon to fight money laundering. Why? Because countries will think twice before going to that country who is blamed with not combating money laundering. So the country, not cooperative countries, will think 100 times before, refusing comply with these guidelines. Yeah.
I agree with that, and I could add that the AMF, the Autorité des Marchés Financiers, publishes the name of the company that do not respect the government's rules. They publish them. And if you are published, you will not be good. And you will have to change. So
Name to shame.
This is why I was saying that the soft law is not so soft as it says. Because it explains that you cannot complain, but you have to explain why. But in fact, if you explain, in France, but not only, the Autorité of Marché Financier will publish an opinion on the company explaining that what you say because you don't comply is not okay, and that you should comply. So if it is published, of course your reputation will be altered. You see? So I agree with what you say.
Thank you.
Thank you. One in the last one.
Assalamu alaikum. My name is Ma'toug Labban and I am a Saudi lawyer. In fact, my point was related to the previous discussion after the speech of Dr. Al-Abid. But anyway, we are still in the subject. In fact, my point is that the compliance or the compulsory of enforcing the corporate governance code in the countries is different from country to other. For example, in UK, the code is compulsory for all its rules. For example, also in Saudi Arabia, the rules of the corporate governance are compulsory in some articles and choiceable in the others. For example, the code in, let me talk about Saudi Arabia to clarify my point. In Saudi Arabia, the corporate governance code enforced on the stake companies. The companies are registered in the stock market. So the companies in the stock markets must follow the rules. And if they don't, there is a sanctions are going to be forced on them by the Ministry of Commerce or by the jurisdictional judicial department. And it is choiceable for the other company are not registered in the stock market, which they have to follow the rules to improve their status, to follow up with the stock market companies. So the influence of the corporate governance code are compulsory on some companies and it is choiceable on the others. And to make it easier, maybe in Arabic. What? بعد ما استنيت هذا كله إيه. طيب هي اللائحة حقت حوكمة الشركات حسب ما احنا درسنا ان هي يعني إلزامية في بعض الدول، كل قواعدها إلزامية، فالشركات ملزمة ان هي تطبقها. في المملكة العربية السعودية عندنا في بعض القواعد إلزامية وبعضها اختيارية. الشركات المساهمة المسجلة في سوق الأسهم يجب ان هي تنفذ القواعد الإلزامية، إذا ما نفذتها حيكون في عقوبات منصوص عليها في نظام الشركات اللي هو نظام الشركات اللي صادرة من خلاله لائحة الحوكمة. فإذا الشركة ما التزمت بلائحة الحوكمة في نظام الشركات في عقوبات تفرض عليها بحسب الاختصاص القضائي، إذا كانت هذه العقوبة عن طريق وزارة التجارة أو عن طريق المحاكم المختصة. الشركات الأخرى اللي ما هي مسجلة في سوق الأسهم السعودية ملتزمة بأنها هي تواكب اللائحة من حيث القواعد حقتها، على أساس إذا كانت تبغى تدرج نفسها أو إذا كانت يعني تبغى توصل للمستوى تنافس الشركات الكبيرة. باقي مؤسسات المجتمع المدني هي مطلوب منها أن تنفذ هذه الالتزامات عشان برضو تواكب المجتمع وتواكب الرؤية اللي هي رؤية المملكة 2030 اللي هي رؤية الأمير محمد بن سلمان اللي هي قائمة على الحوكمة. فهذه هي النقطة وشكرا لكم جميعا.
Mr. Philip, I can translate some of the last part. My colleague, my friend, want to inform you in Saudi Arabia, they have some commitment and some obligation related to Saudi Arabia rules, especially when launching a new company. Some of these rules are applied and by the Minister of Commerce in Saudi Arabia, and I think most of this special SMEs company in Saudi Arabia will respect the rule and regulation. This is a small brief. You have one direct question to Mr. Philip you want to ask? He only sent to you a speech about what's happened in Saudi Arabia, for example, and this is only a small brief about the rules and regulation in Saudi Arabia. If you want to add something, Mr. Philip, you are most welcome, according to my friend. You want?
عندنا مشكلة مع رابية. But thank you for your translation.
Thank you.
And well, what I just can say is that the sanction for non-respecting, if you don't respect governance rules, is not the same for listed company and unlisted company, if I catch a little bit what you say. Of course, if you are a listed company, you will be judged by the market. It is true. And there is a risk of reputation, attempt to your reputation, a very important one. If you're not a listed company, you will still have to adopt and respect governance rules. And the risk can be, of course, of reputation, but it can come from be suing by a shareholder, by minority shareholder. This is why I was exposing about the developing struggle between the board and the shareholders because of climate resolution, because it gives the possibility to the minority to expose new rights, to ask companies to respect new obligation, and the judgment, the consequence, the decision of the judge, for the moment is not so clear. This is what I was saying, and this is why I think it is a very important risk for the companies, and that we have to understand, to take into consideration.
ثانك يو دكتور حاتم. عايزين نعمل كويشن من حضرتك بالفرنش لدكتور فيليب عشان يعني ننهي اللقاء بشكل في تعاون. في حد تاني بعديه بدكتور، بس الدكتور الاول حاتم وبعد كده دكتور ماجد. اتفضل دكتور حاتم.
Philip, no. Philip, I just want you to let the IT to change the photo, because we want to take a good photo for you.
Okay.
This is the first request.
أستاذ أحمد فؤاد غير الصورة بعد إذنك يعني.
Okay.
دكتور حاتم اتفضل.
Merci bien pour l'initiative. Monsieur le professeur, en tant que vous êtes breviste, comment vous voyez la gouvernance en France Et je pense que vous avez étudié un peu la gouvernance égyptienne. Pouvez-vous comparer les deux systèmes?
Alors,
et la différence, bien sûr, entre...
Je vous remercie. Je rappelle que je suis avocat et dans un service de recherche de l'Université de la Sorbonne.
Vous êtes académicien quand même.
Un petit,
c'est ça.
un petit peu.
On est d'accord.
Un petit peu. So I will answer in English.
Yeah, excuse me, before you answer, he has to translate the question in English so we can understand the question before the answer.
You're right.
طيب بالعربي الفرق بين الحوكمة في النظام الفرنسي والحوكمة في النظام المصري. عايزين نعمل مقارنة ومين اللي سابق مين طبعا هنشوف. شكرا.
I think I am not the best specialist to compare French and Egyptian law. I could remember that French and Egyptian law have a lot of similarities that I know. And what I can say about the evolution about governance, but of course it came, as it was explained, from scandals from Maxwell in the 60s. It debuted by comply or explain and non-binding rules. And the more it's evolving, the rules are becoming binding rules. So governments now is a binding system. And for the company, it is something that they have to take in consideration.
Thank you. دكتور ماجد ممكن تعمل مداخلة؟
نعم. Said Fورتويت, I'm gonna say it in Arabic. Dr. Warsama will make it in English, and then you will do the answer. Then we'll go for lunch. Huh?
I try to go.
Okay. طيب. دكتور فورتويت اتكلم وعاد عبارتين في معظم مداخلاته، وهي أنه المجتمع سيحاكم الشركة والقضاء سيحاكم الشركة، أو القانون سيحاكم الشركة في حال عدم الالتزام. والالتزام هي أيضا نقطة مرادفة لمفهوم الحوكمة. نعم، فالسوق والمجتمع سيحاكمك. هذه تخليني أشعر أنه إحنا بخلاف القانون نحتاج ثقافة مجتمع. وباعتبارك مواطن وأستاذ جامعي ومحامي، إلى أي درجة تعتقد أنه المجتمع وثقافته القانونية والحقوقية مطلب لتكون مسألة الحوكمة هي مسألة شائعة الممارسة، هي ليست قانون أنفذ غصبا عني بكل الاحتيالات العربية في ربط الحزام، ليس لأنه أمن لي بقدر ما أنه تجنبا لمخالفة من القانون. فالسيارة وأنا وصحتي وحياتي في 60 داهية، بس أنا ربطت الحزام خدعة، وفي ناس اللي حطته من وراء وفي ناس حطت الشبكة فقط لأنه قانون، مش لأنه ثقافة زي الحوكمة تؤدي إلى تطوير المجتمع، تطوير وتطور المجتمع، ما هوش بس فقط خشية من عقوبة في قانون. فلذلك أسألك كمواطن وكدكتور جامعي في الجامعة يونيفرسيتي وكمحامي، إلى أي درجة الحوكمة اللي نراها في مجتمعاتنا تحتاج إلى ثقافة حقوقية متطورة عن التطوير، عوضا عن أنه هي مجرد عقوبات. الصورة واضحة دكتور؟
Yes, Dr. Majid is asking that some people here have the impression that corporate governance must be a law, to be issued as a law, not as bylaws, okay? And if there is law, then people will be more bound to follow. He put a very good example. While I am driving my car, I put my belt, not because it is my culture or I want that. I did this because it is by law. If I did not do this, then I will be in trouble. Now, the main question, here, or the main concern here, is regarding how to put corporate governance in a way that it becomes obligatory, like other laws, or how to raise the culture of the people in the area, taking in consideration the importance of corporate governance. If we leave it just for the people to apply or not to apply, then it may not be effective as if it is imposed by law. What do you think about this as professor of law and as a lawyer? Which is which, and how to go along? After you comment, I will give my comment also.
Okay, thank you. Okay, thank you. Well, I think governance rules are supposed to be additional rules at the origin that are not in the law, that the company adopts to respect better its interests. I think you cannot avoid to consider that there are laws and government's resolution adopted by the company, both of them. For the enforcement of the government regulation, as a lawyer, I would say that this is what I'm doing, and I try to make these government's rules have the force of the bylaws, because the bylaws have to be respected in the company by all the shareholders, by the directors, by the employee also. You can make them respect this government rules. So this is how you can do to develop government activity in the company through the bylaws and through special regulations that are considered by the bylaws as having the same force and then the same obligation. This is how I say.
If I may comment, as I said in this morning, we have amended the corporate governance rules. This is not easy. If we have a law, then we have to go by the procedure. We have to go to the parliament. Amending a law got very special procedure to be followed. We have the constitution, we have laws, legislations, we have regulations. We have issued the corporate governance rules for banks as a regulation from the central bank, and they have to follow. And also we have added, there are penalties in the corporate governance we have, but administrative penalties. Yani the bank can impose a penalty, a fine, the central bank can impose a fine on a bank that is not following the regulation. However, regarding the criminal issues, this is out of this. This is apart. It is governed by the law, by the penal code. If any person in the company takes a bribe or makes a fraud or criminal breach of trust, this is the penal law is there. So my impression is to keep corporate governance rules as it is, more elastic, more practical, and we have to educate people for the culture of going along with the corporate governance as if it is a law. Thanks a lot.
You just said in the family businesses, the owners, the shareholders, and the staff.
Yeah.
In our culture, it's a shame for the CEO or the chairman to say, this is not in my jurisdiction, you should go to the legal department or to the apartment, or just go to somebody who has the right to do it. And I'm linking the corporate governance, especially in family businesses, with our culture. Everyone here wants to show that he is the big papa. I am the one who knows, I am the one who takes decisions, I am the one, and that makes it difficult to respect the governance, and they damage the business and the future for their generations because they are not respecting it today. The sustainability for the family businesses through generations is very important to be part of family education and the staff education, because you don't want anyone, a member of a staff there to come to me because he likes me. He should come to me because I am the one in concern, or in you know what I mean? Yeah. So it should be part of education, and that what you really mentioned, that to the staff, no one talks about the staff, yeah. But the staff really makes the difference in respecting the governance. Yeah. So are we in the same page in this vision or not?
I think this is why we have to explain that it is the need to enhance the fact that the company has a special interest that is different from the family. So the family is holding the company, but the company is a person, is a moral person. So it has its own interests. I was saying that it has now its obligation. It has more obligation, but it has its own interest. And for the family businesses, I think the key to open the solution is here first, to make them understand that it's not owned by the papa, it's not owned by the brother. It's a business, an independent business. It's an independent interest. And the staff, of course, is very concerned because the staff is not owning the company. It's just running the company. So the staff is supposed to have a good understanding of the interest of the company. And the staff is supposed to have the mission to develop the government's rules in the company, because they are not from they can be from the family, of course. Of course, there can be some members of family in the family businesses that are in the staff, of course. But it should be good to put some extra people that come out from the company and that give good advices to develop the government rules in the interest of the company and not of the family. The family will find its interest through the shares, through the profit and the benefits. But the company is something very, very special.
Not to be like the big sheikh, he has to sit and everybody listens.
Yes.
Yes. دي مشكلتنا. Also, you mentioned that numbers, that the companies with 500 people is the one obliged for governors. Mm-hmm. That means for small enterprises, governance is just a waste of time, because it will not, you cannot govern a company of 5 people. Mm-hmm. So it has to be only with big companies. This is the reason why, or there is another reason for governance as a mandate for big scale companies only?
Well, I think that everybody in the company shall be concerned by the interest of the company. This is what governance is made for, to make powers of the company go well together in the sense of the interest of the company. No conflict, loyalty, confidentiality, and all that principles. So what is possible to do is to create some documents, some internal documents that would be signed by all the people from the company. They accept it as government rules. So it is not the bylaw, it is something under the bylaw. We call that règlement intérieur in French, interior regulation document, you know, where you put all the regulation rules, and that regulation rules should be applied by the directors, by the shareholders, but also by the employees, you see? So in that way, you manage to have a document that is made in the interest of the company by the directors for all the members of the company, and that they should all respect.
So everybody knows and everybody has to respect?
Everybody, because they sign it.
Yeah.
Yeah.
Good. Thank you very much. در حق الدكتور فورتويت.
والآن thanks Dr. Philip for your speech, and now Mr. Maged Karoub will award Mr. Philip for the last session and for achievement in Middle East. في تصوير كاميرا يا سيد. I want to take photo with you also, Mr. Philip. والآن مع تكريم هام جدا لمعالي السيد المستشار أيمن أبو شليب، محامي عام أول بالنيابة العامة لمحكمة النقد، فليتفضل.